We are covering the rules for advertising notary services in a language other than English, specifically the use of the term Notario Publico for the Arizona Notary Public exam. This topic is governed by Arizona Revised Statutes 41273. The exam will expect you to know that a notary public who is not a licensed Arizona attorney is prohibited from using the term notario or notario publico. The reason this law exists is to prevent public confusion. In many Latin American countries, a notario publico is a high-level legal professional with training and authority similar to an attorney. In contrast, an Arizona notary's role is strictly to serve as an impartial witness to signatures and perform other specified notarial acts. The potential for immigrants to be misled into paying a notary for legal advice they are not qualified to give is significant, especially in sensitive immigration matters. The exam will test your understanding of this through scenario-based questions. For example, a question might describe a notary who places an ad in a Spanish-language newspaper that reads Servicios de notario a su alcance. Even though this is a literal translation, the use of notario triggers specific legal requirements. Under A.R.S. Section 41273, if a non-attorney notary advertises their services in any language and uses terms like notario, they must include a specific disclaimer. The required statement is, I am not an attorney licensed to practice law in this state. I am not allowed to draft legal records, give advice on legal matters, including immigration, or charge a fee for those activities. This disclaimer must be included prominently and in each language used in the advertisement. A common exam trap is to present an answer choice with a partially correct or paraphrased disclaimer. You must select the option that reflects the exact statutory language. Another trick question might involve a notary who has a bilingual business card. If the Spanish side uses the term notario publico, the card is considered an advertisement and must contain the full disclaimer. The size of the ad does not create an exemption if it's too small for the full text. The disclaimer must be displayed prominently at the place of business before the notarial act is performed. The penalties for violating this statute are severe and designed to be a strong deterrent. A notary who improperly uses the term notario or fails to include the required disclaimer can face a civil penalty of up to $1,000, and the Secretary of State will permanently revoke the notary's commission. This violation is also classified as a Class 6 felony. To remember this crucial rule, use the mental shortcut. If you use notario, you must say, no soy abogado. This links the prohibited term directly to the core message of the disclaimer, I am not an attorney. This concept is not just about advertising rules, it's about preventing the unauthorized practice of law, a topic the exam takes very seriously. For free practice questions, AI-powered explanations, and more exam prep tools, visit openexamprep.com. That's openexamprep, all one word, .com.